Welcome to I Care a Lot, a legal and ethical discussion surrounding guardianship. If you love someone in elder care, Netflix I Care a Lot is a thriller about guardianship fraud. It's the stuff that keeps families and attorneys up at night. Some say, oh, it's just a story. However, this film isn't explicitly based on a single true story. It's constructed from real life events, namely the myriad of guardianship scams ransacking the wealth and autonomy of countless older Americans. It's estimated that there are between 1.3 million adults in guardianship. And why is there such a wide range? Because the legal records are often sealed and there's no standardized public record keeping compiling comprehensive information on this issue. So if you watch the movie, Marla sets the tone. There are two types of people, predators and prey, lions and lambs. The judge even applauds Marla, stating that she's a well-respected public guardian appointed by the court, specifically him. She confronts the son that she provides the care for what an individual needs, not what they want. She cares from apathy and pride, not from families that don't want to dip into their inheritance to pay for necessary care. We watch her troll for her next new client, or as they refer to as a cherry. No husband, no children, no family, but lots of money. I watched this film and I couldn't wait for the next morning to call Kerry Peck and sponsor this discussion with ElderWorks. Gail, would you like to introduce yourself? And then we'll introduce our two speakers today.
Oh, sure. I'd be happy to. Thank you so much, Susan, for that introduction. Good afternoon, everybody. I'm Gail Nixick with ElderWorks Educational Services. We are so happy to co-sponsor this CE on a very important topic. I would like to introduce one of our presenters this afternoon. That is Diana Law, partner of in Aurora, Illinois. The firm of Law Hesselbaum concentrates her practice in the areas of elder law, estate planning, special needs planning, long-term care, trust, estate probate, litigation, probate administration, and guardianship. Diana's clients are typically people in crisis situations, including families, children with disabilities, and disabled adults. Diana has been selected numerous times as a Rising Star Super Lawyer and as one of the top 10 elder law attorneys in Illinois by Leading Lawyer magazine. The Kane County Bar Association chose Diana as their outstanding new lawyer in 2017 and awarded her the Board of Managers Service Award in 2008, 2009, 10, and 11. The Illinois State Bar Association chose Diana as the 2010 Outstanding Lawyer outside Cook County and named Diana #1 woman lawyer in Kane, Kendall, and DeKalb counties. And Diana in 2011 was elected as president of the Kane County Bar Association, followed shortly by her appointment as to serve the Kane County Public Guardian Administrator. Welcome, Diana.
Thank you very much. Thank you for having me.
Lauren?
And last but not least, we also have Kerry Peck with us. Kerry is the managing partner of the Chicago law firm Peck, Ritchey, where he concentrates his practice in trust and estate litigation, estate planning and administration, guardianship and fiduciary litigation, and elder law. His clients have included families, hospitals, banks, the state of Illinois, Cook County, and the city of Chicago. He is the past president of the 22,000 Lawyer Chicago Bar Association, is a current member of the American Bar Association's Commission on Law and Aging and the Elder Law Section Council of the Illinois State Bar Association. He was retained by the City of Chicago Department of Aging to rewrite the State of Illinois Elder Abuse and Neglect Act. For over 15 consecutive years, he's been selected by his peers as a super lawyer, an attorney to whom other attorneys would refer their family, and he was named a member of the Leading Lawyers Network. He is a recipient of the 2014 Justice John Paul Stevens Award, the Chicago Bar Association's highest honor. He was also selected by IIT Chicago Kent College of Law as one of their 125 alumni of distinction. Together with Law Elder Law and Law Hesselbaum, he co-wrote the books Alzheimer's and the Law and Don't Let Dementia Steal Everything, published by the American Bar Association, and he's a frequent speaker at continuing education seminars for attorneys and healthcare professionals across the country. I'm going to pass it back to Susan. She has a couple of polls for everyone.
So the first question, you can use your keyboard or your mouse. Just want to get a feel. Who's watched the movie? Yes, no, started but couldn't finish. You take a few moments. Wow. More than half have watched the movie. Very good. Okay, the next question. How did this film make you feel? Upset. Yeah, majority was upset. All the above. Not sure. Couldn't believe this could happen, and frightened. Okay. Kerry, you ready?
I am ready. All right, if you don't have your popcorn, you should have it now. And here we go. As you can see, this movie was both action-packed and I would say stunningly emotional. And I would also say, as I've already said, considerably more fantasy than reality. I think it was a bad science fiction movie. And the reality here is, certainly from my perspective, the people that work in the guardianship arena in all different disciplines are extraordinarily caring people. They take care of older adults at the drop of a hat. They go well beyond the call of duty. And the system that is described in the I Care a Lot movie is not the reality that I know, having been involved in guardianship for over 40 years. So, Diana, do you want to open with any comments?
No, I would encourage everybody to see the movie. There's some similarities. So I see the trailer and you talk about, oh, sometimes you do become someone's guardian and you have to tell them that you've become their guardian. And at the end of the day, sometimes people do have to be moved into a facility and their house does have to be sold. But that's about where the similarities end in the movie of what my life experience is as being the public guardian of Kane County for the past decade or so. So it was very intriguing, but I do want people to know the differences. So I'm hoping that we'll be able to talk about that today as well.
Yeah, we don't see the corruption that the movie shows amongst the doctor, and I'll leave it at that at the moment. We just don't see the corruption that this movie portrays as reality. But I think we need to have and are going to have a serious discussion about guardianship and why is guardianship necessary. And often guardianship is necessary to be filed on a very rapid pace. And up on the screen right now, we would file guardianship if, for example, the agent under a power of attorney has abused that power of attorney. Typically, that would occur in the contents of the agent under the durable power of attorney for property, accessing assets of the older adult, and frankly, getting caught with their hand in the cookie jar. Often a guardianship would be filed to remove that agent for abuse of their fiduciary obligations under the power of attorney. Frequently, we file for guardianship on an exigent basis when an older adult is financially exploited, whether that exploitation comes from a caregiver, a family member, the internet, some type of scam. These days, some of the internet scams are called sweetheart scams, where someone on the internet promises to love and adore you as long as you send them your money. And we often see, the necessity of a guardianship in the context of undue influence. That might be the undue influence to sign a power of attorney, giving someone else authority to access assets, as well as a breach of fiduciary duty in the context of, once again, usually power of attorney scenarios, or perhaps even the execution of estate planning documents that occur often on deathbed exploitation cases. So I think that the concept of guardianship, if you don't know, you should know. Guardianship is a judicial determination as to whether another person requires a court-appointed guardian. And our analysis is, does Diana need a guardian? And if so, who should it be? And there are some very strict statutory requirements that must be met and some built-in statutory protections for the older adult. For example, in the movie, we did not see that guardian ad litems were appointed to protect the older adult and report to the court after investigating the circumstances and interviewing the older adult. In Illinois, the appointment of a guardian ad litem is a built-in protection. Guardian ad litem is appointed in 99.999% of the cases to go out and interview the older adult, assess their capacity, investigate the need for a guardianship, and report back to the court, both in person, certainly during COVID via Zoom, and in writing to the court. That is an extraordinary protection to be provided the older adult to prevent Marla in I Care a Lot from taking advantage of an older adult. Next slide, please. So if we need to file for an emergency guardianship along the lines, if we discover, for example, that someone is being financially exploited, or frequently we get calls about an individual, an older adult who lives in a hoarded house, and the house is often filled with cats or dogs, and the older adult is not taking care of the cats or dogs, not taking care of themselves, again, financially being exploited. The agent under a power of attorney is taking advantage as well. In Illinois, and certainly in Cook County and throughout Illinois, they've adopted some modified form of what we in Cook County, we call the CCP 211, which is just Cook County Probate Form 211. It is a physician's report. This is the initial step for filing a guardianship case, whether you're filing on an emergency basis for temporary guardianship, or you're filing in an ordinary course for plenary guardianship. This medical report is required. Now, in the movie, we saw basically where we didn't see money exchange hands, but we saw that the doctor in the I Care a Lot movie literally made up a demented condition of some kind for the older adult, Ms. Pedersen, and indicated that she needed help, couldn't manage her own affairs. The medical reports that we get in the normal course, hopefully they come from an attending physician who has years of experience with the patient. Often the attending physician does not want to get involved, and we hire an expert to go out and assess the older adult. Today, many and not most of those assessments are done by FaceTime or Zoom. I think as more and more of us get vaccinated, we're going to see more and more doctors willing to meet one-on-one as they did pre-COVID. And the medical report requires that the physician indicate whether the older adult, the respondent is the legal terminology, is partially or totally capable of making personal, which is healthcare, or financial decisions. And of course, the question is, what is their malady? Do they suffer from Alzheimer's disease? How far along has the disease progressed? Do they suffer from some form of mental illness, perhaps schizophrenia? Have they suffered from vascular dementia as a result of a stroke? This is important information in the context of a physician writing a report so the judge can make an informed decision. And in all cases, again, the guardian ad litem is going to take a look at that report, match up that report to their face-to-face or virtual evaluation of the older adult, and protect that older adult against the exploitation that we literally see in the I Care a Lot movie. Diana, please at any point jump in here.
No, and I just want to point out too, you talk about the safety protections with the guardian ad litem. The only cases I see in my county and the surrounding counties, I don't venture over to Cook very often for guardianships, but the only time I ever would see a guardian ad litem being waived is when there are parents who are still married and have been taking care of a child who's been disabled since birth, and that child turns 18. So it is extremely rare that there wouldn't be somebody appointed by the judge to go, what we call be the eyes and ears of the court. And they would go out and interview the person who is the alleged disabled person. They would interview their caregivers and their medical staff, any relatives that they know of. And they come back to the judge and let them know what their observations were about the person, about their cognitive abilities, about what they learned talking to the other people that interact with the alleged disabled person on a daily basis or on a frequent basis. And also we have to have a doctor, and this can't be a psychologist. It has to be an MD or a DO, somebody that has a degree of that nature in order to say, yes, this person, we believe this person does need a guardian for the following reasons, and they need help in this specific area. And we believe that either assisted living would be appropriate, or home with full-time care, or skilled care, memory care. And so for myself, if I'm being asked to be someone's guardian, that's huge for me to see what the doctor has to say, because I'm not trained medically, I'm a lawyer. So for me, I rely heavily on that doctor's report as far as making decisions for someone who comes under guardianship for me. So, but both of those things would be, you can't get a guardianship without the guardian ad litem's report and the doctor's report, neither which that I saw was really portrayed in the movie, how it happens in real life.
Can we ask a couple questions that have come in?
Of course.
Having a guardian is very personal. Does the older person get to see or interview the guardian before completing the guardianship?
So I've seen that happen sometimes. I'm usually called on to be someone's guardian if there's a real mess. Typically, as the public guardian, I'm only called upon if, and I would describe it, there's no honest or reliable loved ones. Sometimes this is because they don't have any children, they don't have a spouse, they don't have any siblings or any other family members that would take care of them or would want to take care of them. Sometimes it's because they have children, but they've been the abuser. They've been stealing the Social Security check every month, or they've been taking mom or dad's assets. Sometimes that they're physically abusive. So I have seen it though, where the judge would say, yes, I believe this person needs a guardian, but I do want to listen to, they have enough cognitive abilities to express their preference or their opinion on who should be their guardian. I have seen it, sometimes I've represented clients who they don't necessarily feel that they don't need a guardian, but they want a specific person or a specific private company. And I've seen them interview multiple companies in order to choose who they would like, or offer at least their opinion of who they would like to be their guardian to the court.
What happens if someone is not reachable by Zoom or they refuse to respond?
To go to the doctor? You mean the alleged disabled person?
Mm.
Yeah, this does get to be problematic in some situations, especially, and Kerry can speak to this too, but when I represent people on the private side who want to get guardianship of someone, sometimes it can be problematic if that person won't leave their home, if they won't go see the doctor, but you know that they need care. Sometimes we've had to go to have the judge order them to go to a doctor to allow a doctor to come over to their home. And Kerry, I don't know if you've done other things.
No, I think that, you know, we've had an awful lot of doctors that go into people's homes. Usually when people are recalcitrant or unwilling to cooperate, if the court orders them to do something, not in all cases, but in my experience, roughly, again, 9 out of 10 of these cases, the older adult complies with a judicial order. And even if they've dug their feet in, you know, very, very harshly and deep, so to speak, into the mud, when the judge orders them to do it, most people comply.
How about cases of self-neglect? Do you get guardianship for those too?
Yes, I've been.
Diana, the answer is yes. Go ahead, Diana.
I was saying I've been appointed to take care of people in that situation.
Yeah, and that was one of the issues that we worked on when I was hired under Mayor Daley, the Department of Aging, to rewrite the state of Illinois Elder Abuse and Neglect Act. Self-neglect was one of the important facets of that rewrite, and allows the guardianship to apply to that kind of circumstance. They were also very concerned at the time about what they were calling cat houses, with homes that had multiple cats, and regrettably the urine smell permeated the area, and in a condominium or an apartment affected everybody. So that was, you know, pretty ugly cases.
They are ugly cases, and I'll tell you, it's not as much fun to clean up a home of someone who's been a hoarder or a cat hoarder than this nice lady with the Fabergé eggs and the antiques and all that sort of fun things to deal with. So no, when we go and clean up homes, it's typically someone who has, you know, maybe if they've been at home, they have self-neglected, maybe they're hoarding, maybe they just have a lot of deferred maintenance on their home, so it's an unsafe environment. So it's not as fun to clean up those houses as the movie portrays. They had fun.
I was appointed guardian ad litem by the court to go out and interview and meet with a lady. One of the city officials complained they had the lady had a beautiful mansion in the Ravenswood area, and one of the city officials had complained about the situation. And I went out there with a City of Chicago Department of Aging, very high-ranking official, and she let us into the house, and we got in the house, and she closed the door, and there were no lights on in the house. And the only thing we could see was newspapers stacked from floor to ceiling, and little passageways like a maze, almost like, you know, for lack of a better term, rats going through a little maze. And the two of us looked at each other and went, we're not going to be able to find our way out of this house. And of course, we didn't realize that, and for a few minutes until it got quiet, at the top of the newspapers, and I'm talking floor to ceiling, and I'm probably 10-foot ceilings or more, tall ceilings in a beautiful home, that on top of the newspapers were cats. And I'm talking about many, I don't even know how many, hundreds of cats. Some of them dead, some of them alive, pieces of cat everywhere, and an odor from ammonia and urine that literally in a matter of minutes, we couldn't breathe. So there are some pretty extreme scenarios in those self-neglect hoarding cases. Regrettably, almost all of them, the older adult does not take care of themselves. They never go to the doctor. They put the animals ahead of everything else, and the results are devastatingly bad.
I don't want to get ahead of your presentation, but will you be addressing the requirements to become a guardian, and how do they get paid?
I think that you're right. We ought to maybe discuss it a little further on. Lauren, let's and Susan, if we don't get to it, please bring it to our attention again. Lauren, you want to flip to the next slide, please? So in Illinois, if we're going to file for temporary guardianship, was again focuses on the immediate welfare and protection of the alleged disabled person or his or her estate. We must file simultaneously for plenary guardianship. Plenary guardianship is a long-term permanent guardianship. Temporary guardianship in Illinois can only last 60 days. By court order, it can be extended, and generally only up to 120 days. So that's significant. When a temporary guardianship petition is filed, the court will, as Diana said, appoint a guardian ad litem That guardian ad litem is obligated to personally visit, assuming health and COVID conditions allow, the older adult, the alleged disabled person, wherever they are. So that means, pre-COVID, going in the nursing homes and hospitals was par for the course. If they lived at home, we went there. If we had access to medical records at the nursing home or the hospital, we're obligated to review those and make an assessment of the older adult situation. Likewise, advise the older adult of what I call their probate Miranda rights. You have the right to agree to the guardianship. You have the right to oppose the guardianship. You have the right to a jury trial if you wish, very rarely invoked. You have the right to court-appointed attorney. You have the right to be evaluated by another doctor. So these are very important rights. And again, I don't think that in the course of the movie, we saw anything comparable to protecting the rights of the older adult. Next slide. Diane, you want to talk about that one?
About what the guardians do?
Sure.
So for a plenary guardianship, I would describe that as somebody who has full and lasting guardianship. It's not set as a time frame like the temporary guardianship. So if I get appointed to be somebody's plenary guardianship, I usually am in that role until they either get better, if they're going to get better, which rarely is the case unless there's a traumatic brain injury or a mental health issue. But for dementia and things, people just aren't going to get better from that. And the plenary guardian of the person makes medical decisions, and the plenary guardian of the estate makes financial decisions. So sometimes I can be the guardian of the estate to watch over the money, but they might have a relative who's qualified to act as guardian of the person. So that other person, their sibling, their parent, their child might be making the medical decisions. So the guardian of the person makes all their medical decisions. What we aim to do is to keep people in the most independent living scenario possible. You didn't see that in the movie either. She was shoved right into a memory care unit, locked up, and thrown away the key and give her a bunch of drugs to make her loopy. But we really do try to make sure that people can, if they can live at home, that they're able to live at home, and that they have the care that they need at home if they can stay there. If they cannot manage at home, they might need to go to maybe just a more structured independent living, but in a facility or assisted, and they progress from there. I always, unlike the movie, I like to get court approval for everything, even things that I don't necessarily need court approval for under the statute. If I'm moving somebody to a more restrictive environment, I'm going to get court approval. There's certain medications that they are recommended by the doctor that I don't feel like psychotropic medications for mental health issues. If I am going to consent to them administering these types of medications, I want court approval with a doctor's letter for those types of things as well. If I make large purchases or purchases out of the ordinary, I want to first apprise the judge of what I'm doing. If I have to sell the home, I'm going to get court approval to even list the home, show him what the fair market value is. And I say him because my judge is a him. I'm sure that's not the case everywhere, but out in Kane County, we have one, Judge Grady. So I always make sure that I get approval on all those types of major things that would affect somebody's life, because I want the judge to know what's going on in the life of, it's their ward as well, even though they're under guardianship. I'm their specific guardian, but the court has jurisdiction. And sometimes I have to make decisions at the end of someone's life as well. So it's always, what I would say for best practice for a guardian is to make sure that they, as much as they can, understand what the person was like before they had this disability, what choices they had made in the past that might be able to help me understand what they would have decided to do in the event that they could decide for themselves. If I know if they were a specific religion, maybe that's how they would make decisions for their health care. What they decided to do, maybe if they had a child who predeceased and they cremated that child, I would understand that they are probably okay with being cremated as opposed to buried. So really trying to understand about who that person is and what they would have wanted in the event I'm making decisions for them.
Thank you, Diana. Next slide, please, Lauren. So as Diana indicated, whether it's a plenary or temporary guardian of the estate, guardians come in two different types, two different flavors. Guardian of the estate, which is management of assets, and guardian of the person, which is management of health care and living circumstance. So when a guardian of the estate is appointed, that individual or entity or agency will be empowered to make financial decisions, enter into contracts, take actions to benefit estate tax planning, under court supervision, perhaps undertake estate planning, file lawsuits. Again, all of these are going to require court approval. You didn't see that in the movie. Sell somebody's house, you get a court approval, and apply for government benefits or perhaps Medicaid or SSDI to conserve estate assets. Next slide, please. So at the end of the day, when we take a look at the movie, the question, of course, is, did Ms. Pedersen fit the criteria for guardianship? Well, in Illinois, you need to be age of 18 or older. So we know she was 18, but we didn't see mental deterioration or physical incapacity preventing her from managing her estate or person. We didn't see a mental illness or developmental disability. We didn't see a gambling addiction, an excessive use of drugs or substance abuse. We didn't see her fall prey to a sweetheart scam where she's giving away her money to her internet lover that she's never met in South Africa. And we didn't see her diagnosed with, an alcohol problem or some type of, fetal alcohol problem, which would have related to obviously somebody younger. What we saw was a woman who clearly was fit and capable, and through the corruption of the doctor and the guardian, was, basically hoodwinked into the whole scenario. She, of course, resisted, and the judge really is the one that was probably more appropriately hoodwinked, because the doctor lied about the entire circumstances. If you recall in the movie, Ms. Pedersen fit the bill of this corrupt operation because they called her a cherry. They called her a woman who had tons of money and no family. Well, they ended up making a mistake on the family, if you recall the movie. So clearly, the corrupt scenario with a lot of money and no family is easily understandable in the I Care a Lot movie. But Ms. Pedersen did not fit the criteria for guardianship in Illinois. Next slide, please. So, the concept underlying guardianship is, if someone is competent and able to make their own choices, even if they are competent and exercise poor judgment that might be contrary to their best interest and contrary to what other people believe, it doesn't necessarily make them mentally incapacitated or, under the statute, totally incapable of making personal or financial decisions. So a disagreement with the recommendation of service, i.e., I don't want my arm cut off because of the infection, the refusal to cooperate, and things of that nature, is not solely a basis for guardianship. If an individual understands their decisions, has the capacity to understand the consequences of their decisions, refuses a medical treatment, refuses a medical procedure that their doctors and their family believe is appropriate, they may still, be competent. Next slide, please. So what if Ms. Pedersen had powers of attorney drafted? Would guardianship have been necessary? Well, I think it's safe to say that in the movie, this is Hollywood drama. They're going to create whatever they need to accomplish what they'd like in the drama. But in Illinois, if Ms. Pedersen had proper powers of attorney prepared, she executed them while she was competent, she executed them not subject to the undue influence of others, under the Healthcare Surrogate Act, an agent under a valid power of attorney for healthcare can make her decisions. A court-appointed guardian acting under the Healthcare Surrogate Act, or another surrogate, which we'll explain in just a minute. But had Ms. Pedersen had a power of attorney for healthcare and or a power of attorney for property, her agent could have filed a motion to dismiss the guardianship case. And assuming that document was valid and met the statutory requirements, that would have superseded and overridden the demand in the case, the petitions to file for guardianship. So properly drafted and executed powers of attorney are a viable defense to a guardianship case.
And I think it's important too to note that in a power of attorney, there's a specific paragraph that says to any judge in the future, if I sign this power of attorney now as a competent person, I'm saying these are the people who I'd want to make my medical decisions for me. These are the people who I'd want to make my financial decisions for me. So in the event someone in the future thinks I need a guardian, maybe they don't even know I have powers of attorney, but they think I need a decision maker and they file guardianship, there's a paragraph where I'm telling that future judge, if a guardian is appointed for my finances, I want the people that I put into this power of attorney. If a guardian is appointed for making my medical decisions, I want the people that I have chosen, that I trust while I'm competent, and I'm signing that and it's witnessed. Just as a note to the future judge, if anybody ever thought I needed guardian in the future, these are the people who I want to act for me.
We also have a question. Is it okay if we were to ask you the question now regarding if you feel someone may need a guardian, what's the first step? A referral to the Illinois Department of Aging? What do you recommend?
Diana?
Well, a lot of times people will call a lawyer directly. I get phone calls not only as a lawyer who practices in the area of guardianship, if they feel they need to get guardian of their mother or of their loved one. Typically, I think people call a local attorney who handles that. I do get some phone calls, even from maybe a concerned neighbor. They say, oh, I see that you're the public guardian. What can you do to help? In our county, I would refer them to senior services. I think in Cook County of Catholic Charities is sort of who you would call there. But for senior services, they can go out and do a well-being check. Sometimes they call 911 to do a well-being check, the non-emergency number, just to make sure that the person is maybe taking care of themselves. But usually if people call me just because they're concerned, they don't really want to be the guardian, they just want to make sure that their neighbor or friend or lady at church is taken care of, I usually have them start with senior services.
And I think that Adult Protective Services is generally a good starting point, unless it's a family member you want to call, you know, a local lawyer or somebody who practices in the area and inquire about, you know, obtaining guardianship for your mom or your dad or your grandfather. But Adult Protective Services / the Illinois Department of Aging, or the local senior center, which usually is affiliated with an APS, Adult Protective Services agency.
Diana, you touched on this question a little bit. If you have a good power of attorney for your health and property and everything else is well documented, do you still need a guardian?
No, typically no. So typically you sign powers of attorney so that you have put in place in a legal document a future decision maker in the event you're no longer able to make decisions for yourself. So usually by signing those powers of attorney and having well-drafted powers of attorney that are properly witnessed and notarized, it makes it so in the future you don't need to have a guardian act for you because everything can be taken care of through that power of attorney. Now, if the power of attorney has very limited powers and it doesn't address something specific, you might be in a position in the future where, you know, let's say my power of attorney I signed for property doesn't address anything about my qualified funds or any retirement accounts. So if my kids are trying to take care of me when I'm older, I have dementia, but they can't get into my qualified funds because of the fact that that power of attorney is limited, they might have to go seek guardianship just to deal with that account, to make sure that there's a decision maker for that account. So That's why you have to make sure you have, you know, of course, I'm not a proponent of legal Zoom or those types of power of attorneys, just on Google, what you can find, because there's a lot of scenarios that aren't contemplated. And if you have children that you trust or a spouse that you trust, loved ones that you trust, I'd want you to have very broad, good powers of attorney to make sure that anything in the future can be addressed. Another thing, if you have a power of attorney who then the agent becomes a bad actor and uses that power of attorney to steal your money or to make bad decisions for you or keep you away from other family members, then someone else might petition for guardianship to say, yeah, they have powers of attorney, but that person's doing, you know, something abusive or something, you know, they're sequestering the older adult or whatever they happen to be doing. They might go to guardianship court for that reason as well.
Also, another question here is what kind of medical or mental health training or education is required of someone who is going to be a guardian?
Well, that's a good question. I mean, there's a lot of family members that become their loved one's guardian. There's no specific training if you're a guardian for your family member that I know of. Now in Illinois, you're supposed to get certified. There's a certification that you're supposed to get. I know a lot of private family members don't get that type of certification, and the judges aren't, in where I am, aren't always requiring that you get that certification, even if you're just becoming your mom's guardian or your brother's guardian.
And then the other question is, every court requests a billable hour. How are payments made? People do not have a bottomless well. Please discuss costs. I mean, I'm sure it's very in all different types of costs.
Well, I think a lot of times for people who are becoming a guardian for a family member, a lot of times they don't even charge. So, you know, I might become my mother's guardian, and out of, you know, the fact that I love her, she took care of me, I take care of her, I don't have to send her a bill. For people who are under a guardianship, if they have a private company like Elite Guardian or Midwest Management, any of those types of companies, there's Life Care, if they're providing guardianship services, they will bill by the hour. If people need a public guardian or the state guardian, like myself or someone through Illinois State, what the statute says is they're appropriate to have the public guardian of the county be their guardian if they have an estate of $25,000 or more. So I don't get paid by the county. I actually get paid from the estate of the person that I'm taking care of. So just like a private guardianship company, I keep track of my billable time. I keep track of my hours. You know, a month or 2 months or 6 months, however much time I've spent when it goes by. I would take that invoice to the judge through what's called a fee petition. And I'd say, Judge, this is what I did. Here's a list of everything I've done and all the time it took. And these are the days that I did this work. And I would like my fees to be approved. If the judge does approve my fees, then I am paid from that person's estate. If they have an estate of $25,000 or less, they go to the state guardian because the state guardians don't get paid by that person. It's a service through the state of Illinois. Those people's salaries are paid by the state of Illinois. And that's through the Illinois Guardianship and Advocacy Commission as the state guardian.
Okay, thank you. And also, is it possible for a court scenario like this to be possible with the person in question present?
You know, the alleged disabled people often come to the court. Yeah, very often, I would say. Sometimes they come and they're perfectly happy and content to have a guardian, and sometimes they come because they're not happy at all about the fact that somebody thinks that they need a guardian. But absolutely, in the guardian ad litem, what they do is they apprise those alleged disabled people of all of their rights. And they say, if you want to come to court, I mean, I can't tell you how many times I've arranged transportation so the person could come to court themselves. Again, even if they're not opposed to the guardianship, sometimes they just want to be there. They want to see the process. They want to make sure the judge knows who they are, who can see their face. And then a lot of times people want to come because they're adamant that they don't think they need a guardian. They don't want a guardian. And if they have to have a guardian, they sure don't want so-and-so to be their guardian. So yes, they can be in court and they have every right to be in court.
Great. And this one, I'm sure Diana and Kerry, you've come across this. What if the MD involved in patient's care refuses to complete the CCP 211? What do you do in that situation?
Not really a problem. The court will order that a doctor go out and see the older adult, or order that the older adult go and see Dr. Jones. So the court is empowered and often invokes those powers to order an evaluation.
Okay. And then the other question, I think, so we can then resume after this question to the rest of the presentation. Payments to the guardian ad litem may be fee petition to be reviewed prior to submission to the judge by the court appointed guardian. Is that, so how is that with the payments to the guardian ad litem?
Guardian ad litem is appointed by the court to act as the eyes and ears of the court. All of the fees paid to the guardian ad litem out of the estate of the guardianship must be approved by court. So there's no doubt that the guardian and anybody else that would like to review it in a public scenario can review it. The guardian ad litem is going to be obligated to send their fee petition to the guardian prior to presentation to the court. So yes, the guardian should be able to review the petition of the guardian ad litem.
Okay. And then the one last question as along the lines, what is the process to remove a guardian, particularly in the case of mental health, if the person stabilizes?
If somebody gets better, and this is, I'm sure Kerry's had these cases, I've had these cases. This is actually the happiest day in court. The only real happy times in court are typically an adoption or somebody gets restored. So during the restoration proceedings, if somebody, let's say they were severely mentally ill or just mentally ill, they needed a guardian, but they followed their treatment plan, they took their medications, they consistently worked to get better and better, and they do get to the point where they no longer need a guardian, or maybe they don't need a full guardian, they need a limited guardian just to help with some things. These are actually beautiful proceedings to come back in. We do a petition for restoration of capacity. We get a doctor's note, just like we got a doctor's note to get a guardianship of the person in the first place. And we show the judge what this person has done, how they have progressed, and let the judge know, hey, this person doesn't need a guardian anymore. We want to get rid of this guardianship. And those are actually really beautiful hearings.
Oh, good to hear.
They're pretty rare though. For most scenarios, I think the only restoration cases that I've been involved in are people that suffered closed head brain trauma injuries and make recoveries after long bouts, perhaps at the Rehab Institute or a lot of therapy. Certainly people, regrettably, that suffer from Alzheimer's disease and things like that, they're not coming, their mental status is not coming back. And so there are very few restoration petitions that succeed as a result of usually the underlying mental or physical malady.
Right, thank you.
In the movie, we saw how, the plot moved away from Mrs. Peterson herself, but how are caregivers held accountable for providing effective support? And we saw in the movie, that nursing home withheld food, they over-medicated her, no activities. Who monitors that?
I mean,
Well,
I can't imagine that. I was saying, I can't imagine that actually happening. I mean, the facilities that I have people in, I mean, everything, all the nurses have notes and there's tons of medical records that they keep. A lot of these nursing homes are very concerned about getting sued, and they have liability for things that they would do. If they didn't have a doctor's order to say, because of this diagnosis, give this person this drug at this time and this drug at that time, I just can't see it actually happening. But Kerry, you can.
No, I agree. I mean, clearly there are abuses. I don't necessarily see them as we see in the movie. Nursing homes generally get sued because someone develops a bed sore, or someone falls out of bed and breaks an arm, or falls in the shower. There was lack of supervision. The guardian is responsible to directly respond to your question, to review and oversee the care that an individual is receiving in the nursing home. So that guardian, once appointed by the court, has an obligation to make sure that their ward, meaning that individual, the older adult who now has a guardian, is properly cared for.
Does Social Security recognize a notarized power of attorney, or does it require a guardian to change the destination of payment?
I'm sorry, I didn't catch the first part. You're talking about Social Security?
Social Security, do they recognize a notarized POA
No.
or?
I've had very much trouble getting Social Security to respond to anything from a power of attorney.
Yeah. Social Security has their own rules. They make them up, it appears, on a regular basis. And, you know, they're not the only entity that has their own power of attorney scenarios. We find that a lot of brokers, a lot of banks don't want to honor the statutory forms. They want us to use their own forms. And, you know, Social Security is an entity and a rule maker on its own. I really can't tell you that that anybody has had a lot of success dealing with them.
And what do you do with someone who just refuses to be seen by a physician? Can you get a court order?
Yes, you get a court order compelling them to go to a physician, or that the physician is authorized to enter their home and conduct the evaluation. So I think we should proceed. We're kind of scratching the surface on our slides. Happy to answer questions. But I think we should proceed. So the next slide reflects the Illinois Healthcare Surrogate Act. If you don't have a power of attorney or advance directives in Illinois, this is the Surrogate Act. This is basically the bloodline scenario for who's going to make decisions if you don't decide in advance who you want to make decisions. So note, for example, and I was consulted during the pandemic on a lot of these types of cases, note that the patient's spouse is right at the top. Below guardian, patient's spouse is likely to be the person that's in charge of making decisions. I was called over a weekend, you know, maybe 8 weeks ago, and the scenario was the patient's spouse, while they were in the middle of a divorce, the patient's spouse wanted their spouse to have brain surgery. And the children who come in the next line said, no way in hell. Well, guess what? I mean, this is a case that's ripe for the courtroom, because the spouse doesn't say estranged spouse during a divorce, it says the spouse. And an estranged spouse during a divorce remains the patient's spouse. So this is the bloodline and the relationship of who makes decisions if you don't plan. Noting that in the I Care a Lot movie, you know, this at best unusual son is ranked pretty high up there to make decisions for his mother, should he had wanted to get involved. And all the way at the bottom was the Marla Grayson agency, so to speak. Next slide, please. So we've kind of danced around it a little bit, but what is a power of attorney? Power of attorney is a legal document granting someone else authority. Grant that authority to your agent. It's a person you trust to act for you in certain circumstances, your legal clone. And our picture here in this slide is the Doublemint twins. So they're clones. One could be the agent for the other, and one is it's a principal agency relationship. I'm the principal, not of a school, but creating an agency relationship. If I name Gail as my agent, she acts under my power of attorney. Next slide, please. Like guardianships, powers of attorney come in two different forms. Power of attorney for healthcare, which is clear on its face what it means. It relates to end-of-life decision-making, end-of-life treatment. An aberration, I believe, in the law is that a power of attorney for healthcare can be revoked regardless of mental capacity. So if you have a mentally ill loved one and they sign a power of attorney giving you authority to act, it generally isn't worth too much, because when they go into the manic phase of bipolar disease, they're going to revoke it, and they're entitled to do so under the law. Next slide, please. So in Illinois, we then have a second type of power of attorney for property. Property is a generic term. It relates to assets, not exclusively real estate. That agent can manage your financial affairs upon incapacitation or immediately, depending on how the document's prepared. These documents will avoid the necessity of a guardianship, a lifetime probate, to determine if you're capable of managing your own affairs. They're especially useful to manage assets that cannot be owned jointly, like IRAs and things of that nature. Next slide, please. So there's our dear friendly Marla Grayson, who really, I care a lot. The movie should be called I Care a Lot About Money, because that's really all she cares about. And so if an advance directive is not in place, this is again kind of the bloodline or the entity line as to who's going to make decisions. Noting again that a diagnosis of Alzheimer's disease or dementia alone is not an indication of incompetence. I wrote an article for the Alzheimer's Association magazine. When you're diagnosed, what's your next step? And of course, your next step, because it's a slippery slope declining cognitive impairment illness, is get your documents done promptly. Next slide, please. The role of medical professionals, determination as to whether someone is disabled really is made by a qualified physician. There's a pending bill in the legislature by the psychological professionals, the PhD professionals, to allow them to do evaluations in guardianship cases. To date, it's only MDs and DOs, as Diana mentioned. And of course, the question is, was Ms. Pedersen fairly evaluated? And I think we can see a resounding scenario where the answer is no. The doctor clearly was compensated in some fashion to come up with a completely fabricated report about Ms. Pedersen in the movie. Next slide. So clearly guardianship was not appropriate for Ms. Pedersen. She understood what was going on. She understood what they were trying to do to her. And it seems like it almost, she understood even after they heavily medicated her. And clearly during the course of the movie, this was her loving move on Marla to express her affection and the satisfaction for Marla's job as railroading her, putting her in a facility and stealing all of her money.
I will say my favorite line in the whole movie is when she does say, "Oh, you're in trouble now," because she knows what's coming down the pipe with her son.
Yeah. Clearly, Marla doesn't know that the movie portrays the son as a member of the Russian mobsters. Next slide. So how could that have happened to Ms. Pedersen? Well, number one, it's a movie, it's Hollywood, it has to be drama or it's not going to sell. But elder abuse is a stunning epidemic. I believe that, it's a pandemic or an epidemic. It's comparable to COVID. It doesn't kill as many people, but it does kill older adults that are abused. They never recover. Many times they never recover the ability to earn money. Their money is gone. They're living on state welfare payments or Medicaid payments. And elder abuse comes in a lot of different forms: physical abuse, sexual abuse, emotional abuse, exploitation, neglect, and abandonment. Take a look, the stats are stunning. 1 in 10 Americans over 60 have experienced some form of elder abuse. Next slide, please. So did Ms. Pedersen experience undue influence? Undue influence is often used to persuade someone to sign a document. That document could be a will, it could be a trust, could be a power of attorney document. And so the reality here is I don't recall that she was asked to sign anything. Clearly, she fell prey to the influence of Marla Grayson, but really it doesn't fall directly within the confines of undue influence, check off the box type case. Next slide, please. So could Roman, the Russian mobster, have helped his mother? And the answer is definitively yes. Okay. He could have filed a petition to challenge the guardianship and become guardian for his mother. Had he had a power of attorney for his mother, proper property or health care, he could have gone in and filed a motion to dismiss the guardianship case. And there's little doubt he could have stepped in and been a big player had he chosen to in the guardianship. Next slide. So Diana, tell us how we can make sure this doesn't happen to us, please.
Well, I always say one of the most important things is make sure if you're over 18 years of age that you have a proper estate plan drawn up, which include the powers of attorney for healthcare, powers of attorney for property. You can have a living trust, which allows someone to be the successor manager of your assets that are in your trust if something happens to you. This is the #1 way to make sure that you aren't subject of a guardianship, especially a guardianship of some, rogue person out there who just loves your money more than they love you. So absolutely make sure that your estate plan is in order. Don't get it on LegalZoom or off the internet. It's not going to work. Or from one of those financial advisors. Go to a lawyer. You get what you pay for, and make sure it's a good estate plan for you. There's also other ways too. I think, even at your financial advisors, there's trusted contact. So maybe if your financial advisor is trying to get in touch with you and you aren't answering, not necessarily because you're like Ms. Peterson, who's been now, taken away to a memory care unit and drugged up, but they will say, oh, gee, I can't get in touch with my client. And so I will call this person who's listed as a trusted contact to make sure that you're doing okay as well.
Next slide, please. So in most circumstances, guardianship really is the default plan for disability in Illinois. If you don't do any planning along the lines of what we just indicated, guardianship is quite likely to be the default. And of course, the question is, can they make decisions? Does the person have a proper plan in place? Is the plan appropriate? And are the agents willing to act under the plan? Significant. If you're going to name someone to manage your financial affairs or your health care, talk to them about it. Don't spring it on them when you're not able to have a discussion any further. Next slide, please. So are there people like Marla Grayson and Dr. Amos getting away with this in the real world? My view is that there will always be corrupt people, no matter what, the setting. But I think that in Illinois, we have the system of checks and balances to prevent it. I've not seen this before, this type of, purported corruption. I've been involved in thousands of guardianship cases, again, for over 4 decades. I have been involved in drafting much of the most recent legislation, and I just don't think that it's happening. Next slide. Why am I hearing about guardianship so much these days? I think that, the boomers and the graying and aging of America. Take a look at bullet point 2. About 10,000 people a day are turning 65. By 2030, all boomers will be at least 65. And by 2034, Census Bureau projects older adults will outnumber the people under the age of 18 for the first time in U.S. history. That's pretty extraordinary, and think about it, it's not that far away. So number of adults 55 and older with estate planning, stunning low of 44%.
And I would also add too, it's become sort of a hot topic with, there's the conservatorship, which is what California calls guardianship of Britney Spears out in California. So I think the fact you can read about a conservatorship that maybe isn't what people would like to see of in a guardianship, but you're reading about it in People magazine and Us magazine and on Instagram all the time. I think that makes it more of a hot topic. And I know someone on one of the other panelists told me there's now an Amazon documentary on guardianships. And so I think maybe it's just become something that they can pick up on. I think it started with this lady out in Nevada who got in trouble for being a bad guardian. I think that got a lot of focus, and Hollywood sort of picked it up as well.
So let's flip to the next slide, please, and see if we can get through the balance here. So who needs estate planning? Clearly, everyone needs estate planning. Certainly you need powers of attorney. Minimal estate planning today is powers of attorney, a will, a trust. Many people believe it's too expensive. They don't have the assets. They don't want to get involved. Flip to the next slide, please. What is estate planning? Of course, it's the distribution of assets upon death, the advanced planning for lifetime incapacity, for both healthcare and property management, avoidance of probate. Typically, the best method of avoiding probate today is the use of a revocable living trust. Don't forget, in Illinois, if you die with assets in excess of $100,000 in your name alone, again, in your name alone, not joint tenancy, not payable on death, the law requires we open a post-death probate proceeding in the county in which you die a resident of. That proceeding is going to be required to stay open pursuant to the law, not less than 6 months. Your creditors have 6 months to file claims, even if you have no creditors or believe you have no creditors. The obligation of the probate court is to gather the assets, pay the debts, and distribute the property, typically to 3 categories: friends, families, and charities. So estate planning has a variety of functions, including tax planning and asset protection planning.
And one thing I do want to say, when we're talking about estate planning in conjunction with guardianship and avoiding guardianship, some people might think they don't need an estate plan because if I die, I'm joint tenants on my house. I have beneficiaries on my life insurance policy. I have a beneficiary on my IRA. So it doesn't really matter. I don't need a will or a trust because I have beneficiaries. Well, the problem is those beneficiaries don't take effect until you're dead. The will is just a piece of paper until you're dead. When you have a living trust, you have someone who can manage those assets for you while you're alive, but incapacitated. So it's not just about what's happening when I'm dead. It's about avoiding guardianship and making sure that somebody can manage those assets for me, which cannot be done through a will, because that's nothing but a piece of paper until you kick the bucket and it becomes your last will and testament.
And very important, wills have no validity during lifetime. Powers of attorney have validity during lifetime, and a trust has validity during lifetime. Can provide you a lot of protection. Next slide, please. So the goal of estate planning is both potentially protect assets from creditors, preserve family wealth for future generations, provide income and money to the family under any circumstances, manage assets for someone who's not capable of it, and potentially business succession. Next slide, please. So can what happened to Ms. Pedersen happen to me? I think the answer is you shouldn't let it happen to you. The corruption you won't see, it's not going to happen to you in that fashion. But you may be the subject of a guardianship if you don't plan, if you don't take steps during your lifetime while you're competent to make decisions, appointing someone to manage your affairs. When you become mentally impaired, to whatever degree that is, you should plan in advance. Advanced planning, the key to the game. Next slide. So Diana talked about it a bit. Clearly, Britney Spears and the Free Britney movement is now all over the papers, all over social media, all over the internet. Films like I Care a Lot have brought a lot of awareness to guardianship, conservatorship, to the mainstream media. We're seeing that those stories are spilling over. What do we know about Brittany? Next slide, please. After a series of events showing some type of breakdown in her mental health, clearly I think this is pretty much an infamous photo these days of Brittany shaving her head. Her father became her conservator. She never wanted her father to become conservator. She sought to have a professional company in as conservator. And currently, Bessemer Trust has been named co-conservator after quite a few years of battle to manage Brittany's assets. There's a lot about Brittany and her story that we don't know. We don't know anything really about her about her mental health. We certainly don't have access, and in general, it's confidential and privileged. The circumstances that caused the mental breakdown. Does she have, bipolar disease? Is she schizophrenic? Is she depressed? We don't really know. The media has I think, speculated based upon her conduct. But don't forget, it's 2021, and she's been in a conservatorship since 2008. That's pretty dramatic. So it doesn't look like she's coming out of it very soon. Next slide, please. Some of the snippets of what we do know. Brittany's lawyer said, my client informs me she's afraid of her father. She doesn't want to perform again while her father's in charge. She hasn't talked to her father. And her father stepped down in 2019 as guardian of her person, but not estate. Brittany's mom filed divorce from Brittany's dad in an effort to be involved in the medical scenario. Next slide. So as I mentioned, Free Brittany movement is now afoot. In the past, most free someone movement was somebody behind bars. Perhaps, the guardianship scenario is now drawing some type of analogy. But in 2020, Brittany's attorney stated that the Free Brittany movement is far from being a conspiracy, which has been called, and her conservatorship was once called a hybrid business model, as it allows her to make money and continue to make business deals that she wouldn't make. So clearly, the conservators, the lawyers are arguing Brittany is benefiting, and there's little doubt that she has now assembled a massive fortune of money. Next slide, please. Where do things stand? Brittany wants the conservatorship to be open to the public. Her lawyer argues that she wants everything not to be a family secret, and she's not asking to dissolve the conservatorship, very substantial issue, and I think an admission by her, but rather to change the structure of the conservatorship. So what are our takeaways? We want to plan ahead. Next slide, please. We want to make our wishes known early. We want to choose our agents under powers of attorney wisely. We want to choose our successor trustee in our revocable living trust wisely. But at the end of the day, the top bullet point there is the key to the game. Plan ahead, okay? None of us ever know when we're going to get broadsided by a car, a truck, or a bus. None of us ever know when we're going to have a stroke and be unable to speak or perhaps think in the manner that we used to beforehand. So planning is critical. Questions? Thank you very much for your kind attention. Both Diana's law firm and my law firm offer clients the opportunity to meet with them and sit down at no cost, find out what's going on, how we can help, and see if the chemistry works. If you like us, then we want to work with you. Questions, Susan, Gail?
Do power of attorney advance directives expire?
Typically, I'm sorry, go ahead.
I say they can. Sometimes people put for a specific time period, but typically it's until they pass away or revoke the power of attorney.
Are there instances where the spouse is assumed the POA without the need for any documentation?
Under the Healthcare Surrogate Act, the spouse could make decisions, but again, that's healthcare decisions in a usually emergency situation. The spouse does not assume that decision-making role in the management of assets by statute. So again, get your ducks in a row.
Somebody made a comment that they were named the rep payee for their daughter without any power of attorney or guardianship. They just had to show proof of her disability.
And that's Social Security. And again, there are different accommodations made for people that are caring for a child who's been disabled either from birth or from a young age, as opposed to somebody who might want to get guardianship or be the rep payee of their mother. So that sometimes through Social Security, things are easier when you're the parent of a child with disabilities.
Mm-hmm. For clarification, in a post-divorce situation, can a former spouse legally make decisions for their prior spouse?
If the divorce is finalized, no. If the divorce is pending, the law would allow it.
Unless you have a valid power of attorney that says my soon-to-be ex is not the one who gets to pull the plug, not the one who gets to go into my bank accounts. Make sure you have those powers of attorney done, especially if you're getting a divorce.
Do you need a trust or just a will if you have beneficiaries named and no assets outside of that?
I think we addressed that as, the issue is the will's not valid until you're dead. The beneficiaries don't take effect until you're dead. If you're really looking to make sure that something is taken care of for you, if you're alive but become disabled, you need to do a trust, powers of attorney, things of that nature.
I'm just scrolling through here. Gail, do you see anything else? Are we missing anything?
There's here it says financial exploitation of a mentally disabled person. What actions can the court take as it relates to the action of the exploiter and the return of financial assets of the disabled person?
Well, if an individual has been declared disabled, there is a proceeding in the probate courts called a citation to discover and or recover assets. So the guardian of a disabled person can file under the Probate Act a proceeding to get back the stolen money from the wrongdoer under the auspices of the court. And it's virtually a brand new lawsuit. You have to serve the abuser with summons, issue subpoenas for records, perhaps take their depositions, things like that, and maybe go to trial in the case. But there is a clear route and remedy under the statute, and we litigate those cases all the time. The problem with financial abuse is if the money goes into somebody's arm, up their nose, spent at the racetrack, okay, or is squirreled away out of the country, the likelihood of recovery is very, very, very low. On the other hand, if that abuser goes out and buys a 2-flat and puts it in their name, the likelihood of recovery goes way up.
Kerry and Diana, what kind of services are available for more marginalized people or communities to educate, support, and engage in opportunities to prepare a living will, a trust, or setting up their POAs? Where do these people go if they don't have money?
Well, I think that there are a fair number of legal service operations, Chicago Volunteer Legal Services, a number of the law schools run clinics that prepare these documents. The DePaul Law School runs a legal clinic. I know in my office, we participate and often supervise a program called Wills for Heroes, in which documents are prepared for first responders, police officers, firemen, clearly those people have income. But there are a fair number of free volunteer programs to assist people throughout the Chicago metropolitan area.
Under what circumstances should one opt for an irrevocable living trust versus a revocable living trust?
That's a whole nother seminar. I will tell you, if they go, if whoever's asking wants to go to my law firm's website, they can sign up for a free webinar that'll talk about that type of estate planning.
If you draft POA documents in Illinois and then you move, do you need to have them redone in your new state?
I always tell clients it depends on if that state likes our powers of attorney or not. Wisconsin doesn't even like Illinois powers of attorney. I don't know if that's just like a rivalry situation or what, but I always tell people, make sure whatever state you go to make sure that either that state will accept the Illinois powers of attorney or just they can still keep their estate plan as it is, but maybe get local powers of attorney from the local estate planner.
The issue is that you want to have somebody in the new state take a look at your documents. You don't want to end up going to the hospital emergency room, brought in by ambulance, and they go, do you have a decision maker power of attorney document? And your loved one says, yes, here it is, it's from out of state. And the emergency room staff goes, what's this? And then they call their general counsel who says, send it to my house. I'll review it and determine if it works. And by that point, you know, the passage of time has not helped that patient. So you really want to try and get a local document if you can.
What about the snowbirds? They live 6 months here and 6 months somewhere else. I mean, is that another issue to be concerned about?
I think that you need to be aware of it. There certainly isn't any reason a snowbird can't have a power of attorney from Illinois and a power of attorney from Florida. I mean, we're not talking about break the bank in the preparation of powers of attorney.
I think that's it for the questions. Do you see any more? No? Okay. Thank you everybody so much for joining us. Diana, Kerry, your insightful information is always appreciated. There were really a lot of questions, especially around the film and the reality of it, as you pointed out. So for those of you, the contact information, Lauren just put that up on the screen. Feel free to go to each of their firms for more information and to reach out to them. Please, if you are seeking CE credits, please do fill out your evaluations. ElderWorks will be sending you your certificate in the next couple of days. This entire presentation is being recorded and it will be uploaded on each of our channels on YouTube, but it is not available by email. So thank you so much for joining us this evening.
Thank you.
Thank you all.